You're born in the United States, you grow up here, but one day you're told, sorry, you're not actually an American citizen. That's not a dystopian novel. It could become reality if former President Donald Trump's legal challenge succeeds. Right now, the U.S. Supreme Court has been asked to decide whether the 14th Amendment, the very foundation of birthright citizenship, can be reinterpreted or even rolled back. This case could append nearly 150 years of constitutional law, reshape America's identity, and set off a political and global firestorm. Stay with us, because today we're breaking down what's happening, why it matters, and how the outcome could impact not just America, but the world. Birthright citizenship, also known by the Latin term jus soli, or right of the soil, means that anyone born on U.S. soil automatically becomes an American citizen. It doesn't matter if your parents are tourists, undocumented immigrants, or here on a work visa. If you were born within the borders of the United States, you're a citizen. This principle is enshrined in the 14th Amendment of the U.S. Constitution, ratified in 1868. The key sentence reads, "All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States." The 14th Amendment was passed in the aftermath of the Civil War to guarantee citizenship to formerly enslaved people and their children. It was meant to shut the door on any debate over who counts as American. For over 150 years, courts have consistently upheld this right. The most famous case is United States versus Wong Kim Ark in 1898. In that case, the Supreme Court ruled that a child born in San Francisco to Chinese immigrant parents was, without question, a U.S. citizen. That ruling has been the bedrock of American citizenship law ever since. In simple terms, birthright citizenship is not just a policy, it's part of the Constitution itself. It's the reason America is often called a nation of immigrants, because the moment a child is born here, no matter their background, they're part of the American family. But as we'll see in the next part, that very principle is now under the biggest challenge of its lifetime. On January 20th, 2025, his very first day back in the Oval Office, Donald Trump signed Executive Order 14160, titled Protecting the Meaning and Value of American Citizenship. The order marked a dramatic shift. It sought to end automatic citizenship for children born in the U.S. to parents who are undocumented, on temporary visas, or otherwise not permanent residents or citizens. In plain terms, this meant that simply being born in the United States would no longer guarantee you citizenship. The Trump administration justified the move on several grounds. They argued that the 14th Amendment's phrase, subject to the jurisdiction thereof, has been misinterpreted for decades, and should not apply to children of non-citizens. They claimed that birthright citizenship encourages birth tourism, where foreign nationals travel to the U.S. just to give birth and secure citizenship for their children. They insisted the policy fuels illegal immigration and puts pressure on American resources like schools, healthcare, and social services. For Trump supporters, this executive order was framed as an act of protecting American citizenship and reasserting sovereignty. For his critics, it was an unprecedented attack on the Constitution. Almost immediately, lawsuits were filed across the country, with states, civil rights groups, and immigrant advocates calling the executive order unconstitutional. And that's where the legal battle truly begins. The ink on Trump's executive order was barely dry before the lawsuits started pouring in. Within days, states, advocacy groups, and families directly affected by the policy challenged it in court. Let's break down the key cases. 1. Washington versus Trump. A coalition of states, including Washington, Illinois, and Oregon, filed suit against the administration. Their argument was simple but powerful. The executive order directly violated the 14th Amendment. A federal district judge agreed, describing the order as flagrantly unconstitutional, and issued a preliminary injunction blocking it from taking effect. 2. Barbara versus Trump. In New Hampshire, a class action lawsuit was filed on behalf of families who feared their children would be stripped of citizenship. The plaintiffs argued that Trump's order could leave thousands of children effectively stateless, with no country to claim as their own. Once again, the court sided with the plaintiffs and issued an injunction to halt enforcement. By June 27, 2025, the legal battle had reached the U.S. Supreme Court, but not yet on the constitutionality of birthright citizenship itself. Instead, the justices focused on a more procedural question. Can lower federal courts issue nationwide injunctions blocking federal policies? In a 6-3 decision, the Supreme Court ruled that district courts cannot issue universal injunctions that apply to everyone in the country. Instead, any relief granted by a lower court must be limited to the parties involved in that specific case. This ruling was a partial victory for Trump, because it limited the reach of the lower court's decisions and suggested that nationwide enforcement of the injunctions could not continue indefinitely. However, the court did not rule on the core question, whether Trump's executive order itself violates the Constitution. In practical terms, this means that while the executive order remained blocked for the specific plaintiffs in ongoing lawsuits, the larger question, can birthright citizenship be legally ended, was still unresolved. The stage was now set for a Supreme Court showdown on the merits of birthright citizenship itself. This procedural ruling signaled that the highest court might take up the substantive question soon, keeping millions of people across the country waiting for clarity. By late September 2025, the Trump administration was ready for the next phase, directly asking the Supreme Court to rule on the constitutionality of birthright citizenship. Their argument centers on three key points. Historical intent. The administration claims the 14th Amendment was originally intended to grant citizenship primarily to formerly enslaved people, not the children of foreign nationals. Jurisdiction clause. They argue that the phrase, subject to the jurisdiction thereof, excludes undocumented immigrants and certain temporary visa holders, meaning their children shouldn't automatically qualify. Policy concerns. They maintain that birthright citizenship encourages illegal immigration and birth tourism, creating social and economic strain. Opponents fired back just as strongly. The Constitution's text is clear. Anyone born in the U.S. is a citizen. Supreme Court precedent, particularly Wong Kim Ark v. United States, 1898, firmly established that birthright citizenship includes children of non-citizen parents. Ending birthright citizenship could create thousands of stateless children, violating fundamental rights and creating legal chaos. With this appeal, the Supreme Court now faces a historic decision. It could uphold, partially limit, or strike down birthright citizenship as it has been understood for over 150 years. The outcome will not only affect millions of current and future children born in the U.S., but it could also redefine America's identity as a nation of immigrants. This case is about far more than legal technicalities. It could reshape the very meaning of being American. If Trump wins, children born in the U.S. to undocumented immigrants, tourists, or temporary visa holders would no longer automatically. The debate over birthright citizenship isn't unique to the United States. The political stakes surrounding this case are enormous. For Trump and his supporters, the challenge represents a chance to energize the base by framing the issue as a fight to protect American citizenship and control borders. It is positioned as a major policy victory if the Supreme Court sides in their favor. For Democrats, civil rights groups, and immigrant advocates, the executive order is seen as an attack on the Constitution and a threat to fundamental rights. It has already become a rallying point in political campaigns, with critics warning of the social and legal consequences of stripping citizenship from children born in the U.S. The case could also influence upcoming elections. Immigration and citizenship are hot-button issues that often sway voters, and the outcome could dominate media coverage, political debates, and campaign strategies leading into the 2026 midterms. Internationally, the world is watching closely. A Supreme Court decision changing birthright citizenship in the U.S. could inspire similar debates in other countries and signal a global shift toward more restrictive immigration policies. In short, this case is not just about the law, it's a political flashpoint with far-reaching consequences for America and beyond. So, what's next in this high-stakes legal battle? The Supreme Court now faces a historic choice, and the outcome could redefine citizenship in America for generations. Here are the possible scenarios. 1. The court rules in favor of Trump. Birthright citizenship could be limited or ended for children of certain non-citizen parents. Millions of children could face legal uncertainty, and families may need to navigate complex immigration and citizenship rules. 2. The court rules against Trump. Birthright citizenship remains intact, upholding over 150 years of constitutional precedent. Children born in the U.S., regardless of their parents' immigration status, continue to be automatically recognized as citizens. 3. A middle ground decision. The court could allow limited exceptions, perhaps targeting tourists or temporary visa holders, while leaving broader birthright citizenship intact. This approach would create a more nuanced policy but could also generate legal complexities and ongoing litigation. The timing of the decision is also critical. The court could act quickly, issuing a ruling within months, or it could allow lower courts to continue their proceedings, prolonging uncertainty for affected families. No matter what happens, the decision will not just impact law, it will shape politics, social policy, and America's global image for decades to come. Now it's time to think about what this all means for you and the future of America. Questions for viewers. Should America end birthright citizenship, or is it a fundamental right guaranteed by the Constitution? What would it mean for families and communities if children born in the U.S. weren't automatically citizens? How might this decision affect America's identity as a nation of immigrants? Drop your thoughts in the comments. We want to hear your perspective. Call to action. If you want more in-depth analysis on U.S. politics, global affairs, and how major decisions like this shape our world, make sure to subscribe to the channel, hit the notification bell, and turn on all alerts so you never miss an update. Outro. This isn't just a story about immigration. It's about the Constitution. It's about history. And ultimately, it's about the very definition of America. Stay tuned, because the battle over birthright citizenship has only just begun.